The Supreme Court has reserved its verdict on a batch of petitions challenging the constitutional validity of Aadhaar and its enabling 2016 law. Remember, this comes after a marathon hearing, actually a set of hearings, which went on for 38 days. Now, to discuss this matter further, we're joined by Prasanna S., advocate, and he joins us live on the phone line from New Delhi. Prasanna, thanks so much for speaking to us on Bloomberg Quinn. Now, considering the Supreme Court has reserved its verdict on these batch of petitions, what's the way forward now? What can we expect next?
So there is an interim arrangement in place where all the deadlines have been extended until the judgment is pronounced. We expect the judgment to be delivered right after the Supreme Court's summer vacation, which ends in about 3rd of July or so. It reopens in 3rd July, and we expect the judgment anytime between 3rd July and October when the present Chief Justice retires. So, of course, it's a marathon hearing. It's a historic day where we've had the second longest case hearing in the Supreme Court. So as long as the interim arrangement in place, yes, so nobody can insist on mandatory Aadhaar.
Right.
In terms of the act.
No, so Prasanna, this has been perhaps one of the longest hearings in a long time, and you've been tracking this case from the start. What were the key takeaways for you, and perhaps, what would the bench really be considering the key highlights from this case in terms of the arguments made, according to you? What stood out?
The key highlights in this case is that there are no key highlights. I mean, in fact, all of the issues that were raised in this case are worth a case in itself. So I think since the 1950s, if I remember correctly, we've not had a case that has thrown up so many questions on the interpretation of the Constitution, whether something could be passed as a money bill, not as a money bill. The right to privacy, you had a 9-judge bench sitting over in judgment over the right to privacy. We had a unanimous judgment in August of 2017. All of that happened in this case.
Prasanna, another reason why we were so keen to speak to you today is because you were one of the few lawyers who have been literally live tweeting the entire case, minute by minute, almost like a ball-by-ball commentary, which has allowed so many people to be clued into what this momentous case has really gone through. Tell us what, according to you, were the key points that really stood out in terms of arguments.
In terms of arguments, of course, right to privacy was a key constitutional point. See, that's it. We had it established in our jurisprudence for 40 years, and for some reason, the Union government challenged it in this case. And they lost that case in August of 2017. So the rest of the case will take that color, or the petitioners having won that part of the battle, where to establish that the right to privacy was a fundamental right. And in a matter such as this, where the entire population's biometrics are taken by a government, a democratically elected government, something that had not happened in any other democracy, right? And what it does to human dignity, what it does to all our fundamental rights, whether, in essence, for me, whether we establish a license Raj for fundamental rights, or whether we have inherent fundamental rights. That was the question that arose in this case, and I believe the petitioner's side have done justice to the arguments on that point.